Welcome back to Court TV Live. We are turning our attention now to the state of Ohio. And there's a sentencing hearing that's getting underway for a daughter who admits to causing the death of her mother.
Anna Millette is in court today for sentencing after pleading guilty to involuntary manslaughter and felonious assault. Her mother, Joyce Millette, was killed when Anna used her car to pin her up against a wall. Police responded to the home last summer where they found Anna still in the car in the garage and her mother trapped between the garage wall and the car.
Oh, horrific case. Police tried to intervene, but Millette was able to put the car in reverse and speed away from the scene, where she was later apprehended. She faces 22 to 47 years in prison for those two offenses. And before we take you into court for her sentencing, here's a look at what happened at her plea hearing when Anna asked the judge how much time she faces behind bars.
Do you have any questions for the court about any of the contents of that written plea of guilty form?
So, for the maximum of the mandatory minimum, is it just 21 years then? Or?
So, there is a joint recommendation that has been presented by you through your counsel in the state of Ohio for the court to cap the sentence at 21 years. That's a joint recommendation. Number one, I'm not bound by that recommendation. You understand that?
Yes.
Okay. Number two, when I was going through all of the other numbers as it relates to the sentencing and what your maximum exposure was here, that's something that I have to do at the time of plea with any individual so that they understand what the potential maximum sentence could be in their respective case. Okay. So there's a joint recommendation of a cap of 21 years. I've explained to you what the maximum possible penalties could be.
Yes.
Do you have any other questions as it relates to the question that you just asked? Are you sure? Okay.
Okay, the judge making it known to her at that time, when you're going to plead guilty, kid, guess what? I can go way beyond that 21 years.
Even though the parties agreed to 21.
Yeah, so let's go in and see what the judge does for Anna Millette during her formal sentencing.
This is State of Bar versus Anna Lynn Millette, 2024 CR 435. We are here today for purposes of sentencing. Ms. Pedersen is here on behalf of Ms. Millette, Ms. Barron Allen, and Mr. Tharp on behalf of the state. Ms. Millette had previously entered a guilty plea to count number one as amended, that being an involuntary manslaughter conviction as a felony of the first degree, with a repeat violent offender specification. She also had pled guilty to count number 5 as charged, that being a felonious assault conviction as a felony of the first degree, again with a repeat violent offender specification. Counts 2, 3, 4, 6, 7, 8, 9, and 10 being dismissed on behalf of the state. The matters were continued to today's date for purposes of sentencing so that a pre-sentence investigation could be prepared. Ms. Pedersen, any reason why sentence should not be imposed here today?
No, Your Honor.
Any errors, omissions, additions, or corrections to the pre-sentence investigation?
No.
You've had a chance to review the pre-sentence investigation?
I have.
Are you ready as to sentencing or mitigation?
We are, Your Honor.
Go ahead.
Thank you. On behalf of Ms. Millette, I did submit a written sentencing memorandum. It was filed on August 14th, 2025. We do ask that the court take the information contained in that memorandum into consideration when imposing sentencing. Together, Ms. Millette and I decided to submit that memorandum because we want today to be an opportunity to really have Anna speak directly to the court and allow her family to do the same. I would like to make a few short, quick comments on Ms. Millette's behalf, though. Anna is a young 24-year-old woman. She's a different, much healthier woman that I met over a year ago when I was appointed to represent her. I truly believe this is because she received intensive mental health treatment at Summit Behavioral Health to both stabilize her and restore her to competency. After she was stabilized, Anna worked very hard in treatment to address her mental health issues. She is medication compliant. She has always been open, she's been honest, and she's been very vulnerable throughout this process. Anna has dealt with very serious mental health issues for over 10 years. Her mother was her best friend, her biggest advocate, and her strongest supporter. No punishment that's imposed today can be worse than losing her mother. Anna can't change what she did on June 15th of 2024, and her mother's no longer with us because of it. Ms. Millette's family, including her father, siblings, and other members that are here in court today, have been supportive of Anna throughout this case. They are now her advocates and her supporters. Anna is amazed and eternally grateful for them that they have been through her side through all of this. When Ms. Millette's engaged in treatment, she is a safe and healthy individual. A long period of incarceration will punish her, but it will also punish her family. Ms. Millette's family, the victims in this case, are supportive of her request for a lesser period of incarceration that will enable her to be released and engage in the type of mental health treatment that she truly needs. Lastly, during Anna and our discussions, she's made it clear to me that if anything can come out of this devastation that she has caused, it's that it will bring attention to mental health issues, how difficult they are to manage, and that more resources need to be available for other individuals and families struggling with this issue. Her true hope is that no other family will ever have to endure this type of pain again. Thank you.
Thank you. Ms. Barron Allen, on behalf of the state.
Thank you, Your Honor. Prior to the state providing the court with our recommendation, the father of the defendant, husband to the victim in this case, Richard Millette, would like to address the court.
All right. Go ahead, sir.
Honorable Judge Nagel. My name is Richard Millette, and I speak on behalf of my family. Joyce was my high school sweetheart, my wife, and the love of my life. We grew up together, married for 43 years, raised 5 beautiful children, 4 daughters and 1 son. This past year has been profoundly difficult for our family, punctuated by a tragedy that words cannot fully capture. I hope to provide some context and a heartfelt request for your consideration regarding my youngest daughter, Anna, who stands before you today. Joyce was an extraordinary woman, devoted, compassionate, and a relentless advocate for her children. For nearly a decade, she fought tirelessly to secure mental health care for Anna, who had long struggled with a serious mental illness. Despite her unwavering dedication, Joyce faced insurmountable barriers, limited access to care, systemic delays, and a patchwork of services that never amounted to the sustained help that Anna needed. These failures contributed significantly to the tragedy that ultimately claimed Joyce's life. Joyce would have done anything for her children, including seeking help for Anna until her last moments. Joyce's death was not an act of malice. It was the result of an acute and devastating psychotic episode in which Anna lost touch with reality. While we may never fully reconcile the profound loss of Joyce, I firmly believe this incident stemmed from Anna's mental illness, not a reflection of who she is or the love she has for our family. We do not view Anna as a criminal, but rather as an individual who desperately needs the help that a failing system has not provided. As you considering her sentencing today, I implore you to recognize this and to provide Anna with the opportunity to receive the qualified mental health care she so desperately needs instead of an extended prison sentence. Our family grieves for both Joyce and Anna in this tragedy, and we respectfully ask for your compassionate consideration in your decision today. Thank you.
Thank you.
Okay, there you have it. The father is supportive of it. The prosecution is supportive of it. The 21 years, the minimum. Right. Let's see what the judge does. We'll find out after this break. Stay with us. All right, welcome back to Court TV Live. We're watching this sentencing hearing out of the state of Ohio. The defendant in this case is a young woman by the name of Anna Millette, and the judge has her sentence, her future, in his hands.
Absolutely. She's already pleaded guilty to involuntary manslaughter and felonious assault. Prosecutors say she's the one who killed her mother by pinning her in her car. We heard from her dad. Her dad says she was dealing with mental health challenges and that this was not done in malice. So they've all agreed to 21 years, but it's up to the judge. It could be up to 47 years. Let's pick it up right where we left off.
May it please the court. As this court is well aware, in fashioning an appropriate sentence, the court is to consider the purposes and principles of sentencing, which are to protect the public and punish the offender. And in doing so, the court is to look to the seriousness factors as well as the recidivism factors. The state would submit to this court that the facts of this case, specifically as to the involuntary manslaughter, are more serious than conduct normally constituting the offense of involuntary manslaughter. And as to the felonious assault on a police officer, again, we would submit that that is more serious than conduct normally constituting the offense, especially when you look at, for both charges, the repeat violent offender specification that is attached to each. Additionally, as to the statutory factor, the defendant's relationship did facilitate this offense, and we also believe that recidivism is more likely. In terms of the statutory factors as to recidivism, the offender previously has been adjudicated a delinquent child. The offender has not been rehabilitated to a satisfactory degree after previously being adjudicated a delinquent child, or she has not responded favorably to sanctions previously imposed for criminal conduct. Again, as this court is aware, when the defendant committed this offense, she was on community control after having been released from prison on a judicial release for another felonious assault in which she used a motor vehicle to run over another person. Very similar circumstances. Additionally, the defendant has voluntarily continued the use of her mental health medications on multiple occasions, resulting in her committing a violent felony offense. Obviously, that happened in this offense. The defendant, through her own statements made in the PSI, indicated that she chose to discontinue the use of her mental health medication because she was pregnant at the time of this offense. Nowhere does it indicate that she spoke with mental health professionals in making that decision. Nowhere does it indicate that she worked with mental health professionals in weaning off medication or changing medication that could help her during the pregnancy, that would be safe to take during her pregnancy. Nowhere. When she's in a good state of mind, when she's medicated, she still makes the decision to voluntarily cease taking medication. She did that in this case, and she did it previously in the other felonious assault case. Same thing. When she's receiving treatment, when she's medicated, when she's thinking rationally, she will still make that same decision, and every time it results in her committing another violent felony. Your Honor, the state is well aware and understands that this family has suffered and lost so much. It is truly incomprehensible. And we also know that Anna does suffer from serious mental health issues. But the state took both of those facts into consideration when offering this plea. And we are taking those same facts into consideration in making our recommendation. And Your Honor, the state is going to request that this court impose a minimum term of either 20 or 21 years in this case.
Thank you, Ms. Millette. Anything you wish to say on your own behalf, ma'am?
Yes. First, I'd like to say I have lots of remorse for what happened and regret what happened. Never again will I commit any crime. Losing my mom was the worst thing to ever happen to me, and I cry daily. I love my mom dearly. At the time of the events, I was suicidal and in psychosis. This was a horrible accident. This event has deeply affected me, and I had a major wake-up call that I need to take care of my mental health and make better decisions. Furthermore, I'm sorry for being so reckless and the harm that I brought to my mom and police officers. Additionally, I want to say how horrible I feel for this happening. An innocent life was lost. My mom did not deserve that, and I'd do anything to get her back. Losing my freedom is a small price to pay compared to losing my mom. In the year of being locked up, I've changed dramatically. I'm mentally stable, loving, kind, and back to the normal self my family knows me as. I take the necessary precautions to be the best version of myself I have a daughter now. I have to do better and would like to be out and reunited with my daughter one day. I want to make a positive impact to society instead of a negative one. Furthermore, I want to apologize and say sorry to my family for the hurt they experience every day grieving Joyce Millette, as I also experience this too. My family still supports and loves me, which I'm greatly thankful for. The day of June 15, 2024, the day the crimes took place, is a tragedy. I ask for forgiveness from my family and police officers.
Still with us, attorney and law professor Joe Richardson. Joe, help us understand why we have this leeway that the judge has in terms of the sentencing. Everyone here is saying 21 years, even the prosecution. Why do defendants even enter into these deals where they have to plead guilty when it's not guaranteed?
Well, because the judge is the judge. The judge is the final arbiter of what actually gets sentenced, and the judge gets to think of some things that perhaps the other parties involved don't, and or he may have a different take on those things. That's why ultimately the judge is the judge. Now, depending on where you are, federal, state, there would be sentencing guidelines and things like that. It does go some deal of the way where you have remorse, where you have each of the sides saying, we agree that this is around the time that it should be, et cetera. There's recognition of mental health issues and things like that. And so I think there's a good chance the judge may go along with them. But if it was up to them, ultimately, then the judge wouldn't be the judge. And that's the simplest way to do it, to describe it.
From what you've heard, the tone in the courtroom, do you think that the judge, and we're going to find out momentarily, do you think the judge will go along here with the 21 years? Or, I mean, he made it very clear when she pled that he had the power to upward depart and impose a much different sentence all the way up into the 40s. What's your gut tell you just watching what we've seen in the courtroom?
I think that there's a good chance the judge will go along with it, particularly because of the words of the father. Okay, a family that can forgive and that can provide context and that extend grace and that is not unclear about what justice means and where it comes out, and that believes in tempering justice with mercy. I think that probably goes as far, maybe further than any of the others, the prosecutor or the defense attorney saying this is where it ought to come out. So I would think that there's a good chance, more likely than not, that the judge ends up doing that.
You're so right. That's really three parties that have agreed to this plea deal. It's the prosecution, the defense, and the victim's family here. We're going to get to that judge's sentencing after this quick break. Stay with us. You're watching Court TV.
Tonight on Closing Arguments, a serial killer's daughter vanished. Now her husband stands trial for her murder. We're taking a closer look at key scenes from this case as we break down today's testimony.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Donna Adelson is facing charges of murder, the death of her former son-in-law.
Terrible. Now that Donna has turned into a defendant, what's next for the Adelson clan?
The matriarch mastermind murder trial. Live coverage begins this week on Court TV.
Let's go back to Ohio, where we are watching together the sentencing hearing for a woman who pleaded guilty to penning her mother with her car, Anna Millette.
Yeah, involuntary manslaughter is what she pled guilty to. All parties, the prosecution, the father, and the defense, obviously, are all on board. 21 years, what they're hoping the judge will sentence her to. Let's find out what he decides.
Now, as has been indicated earlier, there are statutory findings that the court has to make, and there are also statutory rules that the court has to follow as it relates to the purposes and principles of sentencing. And they initially deal with the protection of the public and to punish the offender. The state does find in these cases that pursuant to 2929.12 that the offense as it relates to count number 1, dealing with the defendant's mother, is more serious due to the defendant's relationship with the victim and that it helped facilitate the offense. The court also finds under 2929.12D that recidivism is more likely, since at the time of committing the offense, The defendant was under a sanction imposed pursuant to Section 292916, that being a community residential sanction, and 292917, a non-residential sanction of the revised code. Specifically, the defendant was under non-residential sanctions, that being judicial release supervision and or community control, at the time she committed the instant offense for the following. That was a felonious assault as a felony of the second degree in Claremont County case number 2022 CR 521. Additionally, the defendant has a history of criminal convictions. Specifically, she has one misdemeanor criminal traffic conviction for reckless operation, and additionally, the defendant has one felony criminal conviction for felonious assault, a felony of the second degree. Next, the defendant has voluntarily discontinued the use of her mental health medication on multiple occasions, resulting in her committing violent felony offenses. Specifically, the defendant was previously convicted of the felonious assault as a felony of the second degree in Claremont County Common Pleas Court in case number 2022 CR 521 for striking her boyfriend with her vehicle, and that individual suffered numerous injuries and was then transported to Bethesda North Hospital to receive medical care. At the time of that offense, the defendant reported that she had been prescribed numerous medications, but had voluntarily discontinued the use of those medications approximately 1 week prior to that offense occurring. Regarding the instant offense, the defendant was prescribed multiple medications through professional psychiatric services and voluntarily discontinued the use in April of 2024 after a positive in-home pregnancy test. She was then hospitalized at the Claremont Mercy Hospital on 2 separate occasions in May of 2024, where she again was prescribed and was presumed stable on her medication prior to discharge. The defendant admitted to discontinuing the use of those medications immediately upon her discharge from the hospital. Regarding the instant offense, the defendant fully acknowledged her actions resulted in the death of her mother and put the lives of the responding officers and the community at risk. The offenses occurred within approximately 3 months of discontinuing the use of her mental health medication. The court finds that prison is consistent with the purposes and principles of sentencing, and that Ms. Millette is not amenable to available community control sanctions. Additionally, the court finds that a prison sentence is mandatory as to count 1, pursuant to revised code 2929.13F4. Furthermore, the court finds that consecutive sentences are necessary to protect the public from future crime or to punish the defendant, and that consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger that the defendant poses to the public. The defendant's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. The court has considered necessity, proportionality, and the aggregate term when imposing these sentences. First, the necessity findings include the following: the defendant's past criminal and traffic history, which includes convictions for reckless operation as a second offense in a year, and felonious assault. The felonious assault conviction involved the defendant pleading guilty to striking her boyfriend with a vehicle causing physical harm. In that case, the defendant was prescribed various medications but voluntarily discontinued the use of those medications approximately 1 week prior to that offense. Additionally, the defendant had been granted judicial release and was on community control from that case when she committed the crimes in the case here today. The proportionality findings include the following: as previously stated, the defendant's past traffic and criminal history, the similarity involving the weapon used, and her voluntarily discontinuing her medications. In the current case, the defendant voluntarily discontinued the use of her medications due to being pregnant. She was aware of what could happen if she stopped taking her medications, as evidenced by her previous conviction for felonious assault. The defendant struck her mother with a motor vehicle, causing her mother's death. She also placed an officer in peril by her actions after the police arrived to assist the defendant's mother. The defendant's voluntary decision to cease taking her medications put the public at risk, as evidenced by her prior conduct, as well as her conduct in this case. Considering the gravity of the conduct involved and the consecutive sentences imposed, the sentences are certainly proportional to the seriousness of the crimes and the great risk that the defendant poses to the community. At this point in time, it is therefore ordered that the defendant be sentenced to confinement in the Ohio Department of Rehabilitation and Correction as follows. As to count number 1, the defendant shall serve an indefinite prison term for a minimum of 11 years, up to a maximum of 16 and a half years. On count number 5, the defendant shall serve an indefinite prison term for a minimum of 10 years, up to a maximum of 15 years. The court will also order that count number 5 will be served consecutively to count number 1. Thus, the total aggregate indefinite prison term is a minimum of 21 years, up to a maximum of 26 and a half years. Ms. Millette will be given credit for the 427 days that she has served so far, and she will be ordered to pay the court costs in full. Ms. Millette, you understand that post-release control in this case is mandatory for up to 5 years, but not less than 2 years. If you violate post-release control, the parole authority could return you to prison for up to 9 months for each violation, up to a maximum of half your original sentence. If you are convicted of a new felony while on post-release control, in addition to any prison term imposed for the new felony, you may receive an additional prison term of the greater of 1 year or the time remaining on post-release control. You are ordered to serve as part of this sentence any period of post-release control imposed by the parole board and any prison sentence imposed for violation of that post-release control. As I indicated moments ago, court costs in this case are mandatory, but if the costs are not paid, you may be ordered to perform community service up to a maximum of 40 hours per month until they are paid in full. You would receive credit towards your costs at an hourly minimum wage rate in effect at that time. Lastly, Ms. Millette, you have the right to appeal the conviction and the sentence herein. If you're unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed without cost to you. If you're unable to pay for the cost of documents necessary for an appeal, those documents will be provided without cost to you, and you have the right to have a notice of appeal timely filed on your behalf. Ms. Pedersen, anything further on behalf of Ms. Millette?
No, Your Honor.
Ms. Barron-Allen, anything further on behalf of the state?
No, Your Honor, thank
All
you.
right, thank you. Good luck.
Oh, Judge, I guess, do you want to put on the record any jail time credit?
It did, 427 days.
427, all right, thanks.
Yes.
All right, there you have it. The judge agreeing with the plea in this case, 21 years minimum, 26 years mandatory for 24-year-old Anna
I'm
Millette.
glad he did.
Stuck with it.
When you've got all the parties in agreement,
Right.
it would be, judges shouldn't interfere with that.
She's got an 8-month-old daughter. She'll be out probably when she is in her early 40s, late 30s.